Keep Our Republic is a nonpartisan, nonprofit organization. Since the spring of 2020, we've been doing our part to help keep our republic. We do it through hyper-localized civic education. We talk with Americans through town halls, legal seminars, media briefings, and other events. We know a lot of Americans have a lot of questions right now about how our democracy really works. Questions like, what actually happens behind the scenes on election night, and just what is the power of the federal courts? That's why we're talking directly to election officials and judges from across the country. Together, we can help answer some of those questions.
Welcome back, everyone, to Keepers of Our Republic. My name is Brooke Bergen. I am the Special Projects Manager here at Keep Our Republic. We are a nonpartisan nonprofit, and each week I am speaking with the unsung heroes of our democracy, the election workers, the judges who are working often quietly behind the scenes to support our democratic institutions. U.S. attorneys have been in the news lately, and not always for a good reason. There have been mass resignations, mass terminations, and a feeling among everyday citizens that what is supposed to be an independent prosecutorial office has become increasingly weaponized for political gain. Here to talk about these issues facing the U.S. attorneys' offices today, the historical importance of these positions, and what it means to serve in this office with integrity, I am joined by Judge John Martin. Judge John Martin served on the bench as the United States District Judge for the Southern District of New York. He was also the U.S. Attorney for the Southern District and Assistant U.S. Attorney for the Southern District of New York. He also has a long career in private practice at a number of firms. We're excited to talk with him about some of these issues here today. Thank you, Judge, for joining, and welcome to the podcast.
Happy to be here.
Well, Judge, you've had a number of really important roles in your career. Obviously, you sat as a jurist for the Southern District of New York, but prior to that, you were also an assistant U.S. attorney, as well as chief appellate attorney for SDNY. You were the assistant U.S. Solicitor General, as well as a number of years in private practice at a number of important firms. Today, I was hoping we could jump in a little bit about the AUSA and U.S. Attorney side of things. We're hearing a lot about these positions in the news right now. DOJ is having a difficult time recruiting what has historically been one of the most sought after jobs for early and mid-career attorneys. And there's a real concern about the politicization of this role. Of course, it is the role of a prosecutor is an executive position. It is a political position, but they occupy a very special sort of have traditionally occupied a very out of the political fray position compared to other roles in the executive office. And we're seeing real pushback on that right now, and we're seeing real concerns by the public about the weaponization at DOJ against people who might be speaking up or are seen as standing against some of what this administration is doing. So, Judge, before we jump into all that, let's take a step back and explain to me, like I didn't take my middle school civics class, what is a U.S. attorney and what role do they play in our justice system?
Well, the role of U.S. attorney goes back to the first Judiciary Act. It set up our court system. And it said that in each district, there should be a United States attorney appointed by the president and confirmed by the Senate. There was no Justice Department. The U.S. attorney was basically the government's lawyer in the district. Every state has at least one district. Larger states have more than one because of their population. For example, New York has 4. But basically, starting out, the U.S. attorney was the government lawyer in all cases. The only other, the attorney general, represented the United States in the Supreme Court, the function now held by the Solicitor General. So that was, and in some sense, is how most U.S. attorneys regard the position today. They're established by the Constitution for the president to act on behalf of the United States in both civil and criminal matters. The situation changed in the late 1800s when the Department of Justice was created, so that now the U.S. Attorney reports to the Attorney General, and the Attorney General has the power to appoint Assistant U.S. Attorneys and has the power to set up special branches of the justice within the Justice Department within the district. For example, there have been antitrust divisions in local districts controlled totally out of the Justice Department. But basically, the function of representing the government falls on the United States Attorney for the district.
So, what role, obviously, there are going to be the government's represented in both the civil and criminal matters before the court. Um, can you kind of describe for our listeners that has led this position to have sort of an outsized importance in the day to day operation of our criminal and civil legal systems? Is that right?
I mean, historically, the U.S. Attorney's Office was the place where all criminal cases were prosecuted, civil cases were prosecuted and defended, but they basically acted independently. And in the Southern District of New York, where I was the U.S. Attorney, we took that independence seriously. It is important for the public acceptance of the work of the courts, the U.S. attorneys, for them to have confidence in the integrity of the people in those positions. And as U.S. attorney, one of my principal functions was to maintain that integrity and to be sure that the people who reported to me met the highest ethical standards, which in fact they did.
Yeah. And you've hit it so precisely. You're a government attorney, but you are expected to be, kind of removed from the political fray. You are not, you don't have individual clients. It's what makes that position so different from almost any other attorney position in our system. Did you ever experience when you were an AUSA or the U.S. attorney? Did you ever experience political pressure to bring a certain type of case, or to bring a certain prosecution, or to lay off and to decline to prosecute a certain type of case?
No, because the tradition was so well established. I grew up under Robert M. Morgenthau, who was the United States Attorney for the Southern District of New York in the 1960s. And the worst thing that could happen to a potential defendant in a criminal case was for some politician to call Bob Morgenthau and tell him to take it easy on this guy, because Bob's reaction would be to walk into your office and say, "You handling this case? I just got a call from this politician. If this guy has committed a crime, make sure you nail him." And maybe of some interest, I mean, historically, there were periods where the U.S. attorney's offices were more political, in the sense that the people who were appointed at the change of administration, there would be a change in U.S. attorneys. That still happens today, because there are public policy issues that come up that is important that the president have somebody that he has confidence in, or she has confidence in. However, back in the bad days, when the administration changed, the entire staff changed. Everybody was expected to resign. Fortunately, that has changed over time, and indeed, much more emphasis is being placed on the actual selection of the U.S. attorney. Again, historically, and under the Constitution, the president selects the U.S. attorney. In practice, the president doesn't go running around looking for people to be U.S. attorney. Generally, the president relies on a recommendation from the senator of his party within the state. Now, again, that has often been based on strict political considerations. However, I was elected by Senator Moynihan, who was one of the leaders in setting up commissions of law or committees of lawyers to select the best person available. And they made one mistake with me, but that was how the system worked. And that has been followed by more and more of the senators around the country. So that you have a judicial selection committee that selects U.S. attorneys and judges, which focuses simply on the merits of that candidate, given their background and experience.
Two things you touched on there that I really want to jump into. So the first, going back for a moment, you pointed out that historically it was at least at one point that when a new administration would come in, it wasn't just the U.S. attorney that was let go and a new one was put in, but basically the entire staff or the legal staff would be replaced, and that system has largely gone by the wayside. Talk through what is important about having continuity and retention within the U.S. attorney's offices, even as administrations change and as, um, policies might change or different priorities in policy might change, why we don't want to have huge turnover in mass numbers at these offices.
Well, I think, and again, it's part of the historical context. Earlier in our history, life was simpler. We didn't have telephones, we didn't have computers, we didn't have wire systems, and the crimes were much simpler. You committed piracy, you robbed a stagecoach. Today, the level of criminal activity extends worldwide. You have securities markets, you have uh, tax statutes that are complex, so that the normal investigation now and it's developed even in my lifetime. When I was an assistant U.S. attorney, we still had very simple cases of people stealing a bag from the Port Authority bus terminal. It was a federal crime because that bag was traveling in interstate commerce. The FBI was prosecuting people all the time who would take a car from New Jersey and go on a joyride into New York. They crossed the state line, so that made it a federal crime. Well, as a result of people like Bob Morgenthau and other U.S. attorneys, they realized this was a waste of federal resources. The complex criminal organizations, such as organized crime, the complex crimes such as securities fraud, and all kinds of frauds that have developed over a worldwide basis, required a much more professional staff of people who were there for years to develop these very complex cases. So you have to have, to be effective, you have to have a well-experienced staff.
Yeah, and obviously in your district, was perhaps the best example of that. For those of you who are unfamiliar, the Southern District of New York is going to include Manhattan, which is of course going to include all of the financial crimes and is an epicenter, not just for those types of crimes, but you've got a lot of interstate commerce happening. It's a major corridor for more conventional type crimes, right? You've got your trafficking, your gun trafficking, your drug trafficking, but particularly those financial transactional crimes are mostly being handled in SDNY, and these are massive, multi-year investigations.
Yeah, I mean, as an assistant U.S. attorney, I tried a case involving the interstate and foreign transportation of stolen microorganisms. Somebody was trying to set up a competing. They stole from American Cyanamid and tried to set up their operations in Italy where there weren't patent laws.
Wow.
So they're all, that's a type of kind of complex crime that that took several years to investigate.
Right. And if we have mass resignations or mass terminations and you aren't able to fill those positions, there's a huge wealth of knowledge that's being lost. And no one wants attorneys do their jobs and they do them well, and we've all had to transfer case files to another attorney, whether that's going from, trial prep and now another attorney is going to actually try the case. But to constantly,
There's a bigger problem than that.
yeah.
It's why those mass resignations take place.
Yeah, I did want to jump into that because you kind of hinted at that earlier. So talk to us a little bit about what we've been seeing recently.
Again, what is central to the work of the courts and the Justice Department is public acceptance. Justice Frankfurter said of the courts, the courts don't have the power, an army, they don't have any power other than the public acceptance of what they do.
Mm-hmm.
And it's critical that people think that the U.S. attorneys, the judges, are people of integrity, that the system is fair, it's not rigged. So they have to have confidence that the people exercising this important power can be trusted and will maintain the highest standards of the profession. And you're seeing resignations where people saying, I'm resigning because I am being forced to do things that I think violate the code of professional responsibility.
Mm-hmm.
That's a terrible blow to the integrity of the system.
Yeah.
That is doing massive damage.
And
Go
ahead.
We now have an executive order saying that it was there to fight the weaponization of the Department of Justice, which would be a good thing, except it is being used to weaponize the Department of Justice and undermine the credibility of the Department of Justice to the public.
Yeah. Yeah. And it's affecting not just retention and obviously people who are resigning in protest because they believe they're being asked to do unethical things or people being outright terminated. But it's interesting. I was just reading an article that came out a few days ago. We're here at almost the end of March, where certain U.S. attorneys' offices districts are lowering admission or application standards. It's been customary in the last few years that attorneys need at least 1 year of postgraduate experience before they can apply to be an assistant U.S. attorney. Well, in places like Florida, they're getting so few applicants for these ordinarily highly coveted, highly prestigious positions that they're now saying you can apply straight out of law school. And so I'm sure there are qualified candidates straight out of law school, but it really speaks to the larger issue that is happening in the legal profession right now.
Absolutely. I mean, the Southern District of New York has always been viewed as one of the best prosecutor office in the country. And that isn't because people like me were U.S. attorney. It's because the people that they hired were people of the highest caliber. The job of being an assistant U.S. attorney in the Southern District of New York is harder to get than being employed by any law firm in the city of New York. I am sure every major law firm in the city of New York has partners who have been turned down when they applied to the U.S. Attorney's Office. That is not to denigrate their ability. It's just an example of a great quality you get when you give people the opportunity to do the right thing every day.
Yeah. So let's talk about the transition you made in your career. So you obviously served with great distinction as a prosecutor as well as in private practice, but you did obviously eventually step up onto the bench. How did your views of the system shift once you put on the robe and moved from prosecutor to actually sitting as a jurist on the bench?
I don't think my views of the system shifted at all. My role obviously shifted. And I think the fact that I had been a United States attorney was very helpful in my role as a judge, because if a prosecutor was making a mistake or was going beyond what had traditionally been done in terms of prosecutorial discretion, I could recognize that.
Mm-hmm.
it was interesting when I was on the bench several years, and there was a change of administration, and the Law Journal did an article trying to find out if you could see in the results of the courts the difference in the change of administration made. And it said in the district courts, not at all. And in the circuit courts, occasionally the appellate courts, there were some differences. The interesting thing they said that among the criminal defense bar, the judges judged to be most even-handed, which I take to mean pro-defense, were Ray Deary, Ed Corman, John Keenan, and John Martin. And what do we have in common? Corman, Martin, and Deary had been U.S. attorneys, and John Keenan was a longtime state prosecutor. Because we knew the system. We knew when assistants were getting to the line.
You know, we talked a little bit about public trust when we were talking about what's at stake when people are losing trust in these public prosecutors' offices. How important do you think having trust in the judiciary system is important to have for a functional legal system in this country?
Absolutely essential.
Yeah.
I mean, as I indicated earlier, if the courts, yes, we have marshals who go out and enforce specific orders, but the general acceptance of what people are told, this is the law, this is what you have to follow. It's not going to work if people say, who's that jerk?
Yeah.
You know, if there's not trust that you're doing it fairly, they're not going to be accepting it.
Yeah. Yeah, there's no enforcement mechanism inherent to the system. The enforcement mechanism is that we all have buy-in.
I mean, our system works because people accept the fact that you should do what is right and do what is legal. And if that breaks down, then it's every man for himself.
Yeah. So for any young lawyers or perhaps future assistant U.S. attorneys, future state attorneys who may be listening, what advice would you give them about what it will mean to do their job with integrity, particularly, in the next couple of years?
I think that what means is simply you're there for the sole purpose of seeing that justice is done. Justice is done fairly, and do you play by the rules? The lawyers have spent a lot of time developing the canons of law, canons of private practice. And if you stray from those, you're undermining everything you do.
Yeah. Why? And then speaking more to our broader audience, the everyday, the civilians, the non-lawyers who may be listening, what do you want them to understand about how our justice system is designed to work, even when times feel contentious and polarized like they do right now?
I think that is the genius of the Constitution. It is set up of limited powers. There was a case called Ex parte Mulligan from the Second World War, where they were trying to use military courts in Hawaii, and the Supreme Court rejected it. And it said, we need the protections that court provides. They said, in effect, our framers recognize that those people who ascend to power may not always be the upright and outstanding people that we found in Lincoln and Washington. And that they set up a system of government to be sure that the people who wielded power had to wield it under the Constitution and in accordance with what is right, in accordance to the law. And for that reason, they set up a judicial system that was there to place boundaries on the executive and the Congress. And it is important that the public recognize when those judges act to enforce the Constitution and enforce the law and say, no, the executive cannot do something, or Congress cannot do something because it is unconstitutional. They are not acting out of personal bias. They're acting under the rules set down by the founders of this country when they adopted a very brilliant constitution.
So well said, Judge. Judge, thank you so much for joining us this week. Thank you for many years of public service and, of course, the work you are continuing to do with the Article 3 Coalition, along with your other judicial colleagues. We are so grateful for your time and for all of the work that you are continuing to do right now.
Happy to be with you.
Thank
Thanks.
you so much.
Bye.
If you like this episode, please share it on social media and tell your friends. It's the best way for folks to find out about us. I hope you'll agree that our guest is indeed a keeper of the Republic. If you want to learn more about how you can help keep our Republic, stop on over to our website, keepourrepublic.org.